Everyone. We're continuing with part 2 of DC versus Heller. So right now we're in Justice Stevens' dissenting opinion. So compare earlier at 584, defining bear arms to mean carrying a weapon for a particular purpose, for confrontation, with earlier at 586. The phrase bear arms also had at the time of the founding an idiomatic meaning that was significantly different from its natural meaning: to serve as a soldier, do military service, fight, or to wage war. But it unequivocally bore that idiomatic meaning only when followed by the preposition against. Emphasis deleted, citations, and some internal quotation marks omitted. The amendment's use of the term keep in no way contradicts the military meaning conveyed by the phrase bear arms and the amendment's preamble. To the contrary, the number of state militia laws in effect at the time of the Second Amendment's drafting used the term keep to describe the requirement that militia members store their arms at their homes, ready to be used for service when necessary. The Virginia military law, for example, ordered that every one of the said officers, non-commissioned officers, and privates shall constantly keep the aforesaid arms, accoutrements, and ammunition ready to be produced whenever called for by this commanding officer. Keep and bear arms thus perfectly describes the responsibilities of the framing era militia member. This reading is confirmed by the fact that the clause protects only one right, rather than two. It does not describe a right to keep arms, and a separate right to bear arms. Rather, the single right that it does describe is both a duty and a right to have arms available and ready for military service, and to use them for military purposes when necessary. Different language surely would have been used to protect non-military use and possession of weapons from regulation if such an intent had played any role in the drafting of the amendment. When each word in the text is given full effect, the amendment is most naturally read to secure to the people a right to use and possess arms in conjunction with service in a well-regulated militia. So far as appears, no more than that was contemplated by its drafters or is encompassed within its terms. Even if the meaning of the text were genuinely susceptible to more than one interpretation, the burden would remain on those advocating a departure from the purpose identified in the preamble and from settled law to come forward with persuasive new arguments or evidence. The textual analysis offered by respondent and embraced by the court falls far short of sustaining that heavy burden, and the court's emphatic reliance on the claim that the Second Amendment codified a pre-existing right is of course beside the point, because the right to keep and bear arms for service in a state militia was also a pre-existing right. Indeed, not a word in the constitutional text even arguably supports the court's overwrought and novel description of the Second Amendment as elevating above all other interests the right of law-abiding, responsible citizens to use arms in defense of hearth and home. The proper allocation of military power in the new nation was an issue of central concern for the framers. The compromises they ultimately reached, reflected in Articles 1, militia clauses, and the Second Amendment, represent quintessential examples of the framers splitting the atom of sovereignty. Two themes relevant to our current interpretive task ran through the debates on the original Constitution. On the one hand, there was a widespread fear that a national standing army posed an intolerable threat to individual liberty and to the sovereignty of the separate states. Governor Edmund Randolph, reporting on the Constitutional Convention to the Virginia Ratification Convention, explained, "With respect to a standing army, I believe there was not a member in the Federal Convention who did not feel indignation at such an institution." On the other hand, the framers recognized the dangers inherent in relying on inadequately trained militia members as the primary means of providing for the common defense during the Revolutionary War. This force, though armed, was largely untrained, and its deficiencies were the subject of bitter complaint. In order to respond to those twin concerns, a compromise was reached. Congress would be authorized to raise and support a national army and navy, and also to organize, arm, discipline, and provide for the calling forth of the militia. The President, at the same time, was empowered as the Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. But with respect to the militia, a significant reservation was made to the states. Although Congress would have the power to call forth, organize, arm, and discipline the militia, as well as to govern such part of them as may be employed in the service of the United States, the states respectively would retain the right to appoint the officers and to train the militia in accordance with the discipline prescribed by Congress. But the original Constitution's retention of the militia and its creation of divided authority over that body did not prove sufficient to allay fears about the dangers posed by a standing army. For it was perceived by some that Article 1 contained a significant gap. While it empowered Congress to organize, arm, and discipline the militia, it did not prevent Congress from providing for the militia's disarmament. As George Mason argued during the debates in Virginia on the ratification of the original Constitution. The militia may be here destroyed by that method which has been practiced in other parts of the world before, that is, by rendering them useless, by disarming them. Under various pretenses, Congress may neglect to provide for arming and disciplining the militia, and the state governments cannot do it, for Congress has the exclusive right to arm them. This sentiment was echoed by a number of state ratification conventions. Indeed, it was one of the primary objections to the original Constitution, voiced by its opponents. The Anti-Federalists were ultimately unsuccessful in persuading state ratification conventions to condition their approval of the Constitution upon the eventual inclusion of any particular amendment. But a number of states did propose to the First Federal Congress amendments reflecting a desire to ensure that the institution of the militia would remain protected under the new government. The proposed amendments sent by the states of Virginia, North Carolina, and New York focused on the importance of preserving the state militias and reiterated the dangers posed by standing armies. New Hampshire sent a proposal that differed significantly from the others, while also invoking the dangers of a standing army. It suggested that the Constitution should more broadly protect the use and possession of weapons without tying such a guarantee expressly to the maintenance of the militia. The states of Maryland, Pennsylvania, and Massachusetts sent no relevant proposed amendments to Congress, but in each of those states, a minority of the delegates advocated related amendments. While the Maryland minority proposals were exclusively concerned with standing armies and conscientious objectors, the unsuccessful proposals in both Massachusetts and Pennsylvania would have protected a more broadly worded right, less clearly tied to service in a state militia. Faced with all of these options, it is telling that James Madison chose to craft the Second Amendment as he did. The relevant proposals sent by the Virginia Ratifying Convention read as follows. 17th, that the people have a right to keep and bear arms, that a well-regulated militia, composed of the body of the people trained to arms, is the proper, natural, and safe defense of a free state, that standing armies in the time of peace are dangerous to liberty, and therefore ought to be avoided as far as the circumstances and protection of the community will admit, and that, in all cases, the military should be under strict subordination to and be governed by the civil power. The 19th, that any person religiously scrupulous of bearing arms ought to be exempted upon payment of an equivalent to employ another to bear arms in his stead. North Carolina adopted Virginia's proposals and sent them to Congress as its own, although it did not actually ratify the original Constitution until Congress had sent the proposed Bill of Rights to the states for ratification. New York produced a proposal with nearly identical language. It read, that the people have a right to keep and bear arms, that a well-regulated militia, including the body of the people capable of bearing arms, is the proper, natural, and safe defense of a free state, that standing armies in time of peace are dangerous to liberty and ought not to be kept up except in cases of necessity, and that at all times the military should be kept under strict subordination to the civil power. Notably, each of these proposals used the phrase keep and bear arms, which was eventually adopted by Madison, and each proposal embedded the phrase within a group of principles that are distinctly military in meaning. By contrast, New Hampshire's proposal, although it followed another proposed amendment that echoed the familiar concern about standing armies, described the protection involved in more clearly personal terms. Its proposal read, 12th, Congress shall never disarm any citizen unless such as are or have been in actual rebellion. The proposals considered in the other three states, although ultimately rejected by their respective ratification, conventions are also relevant to our historical inquiry. First, the Maryland proposal, endorsed by a minority of the delegates and later circulated in pamphlet form, read 4. That no standing army shall be kept up in time of peace unless with the consent of 2/3 of the members present of each branch of Congress. 10. That no person conscientiously scrupulous of bearing arms in any case shall be compelled personally to serve as a soldier. The rejected Pennsylvania proposal, which was later incorporated into a critique of the Constitution titled The Address and Reasons of Dissent of the Minority of the Convention of the State of Pennsylvania to their Constituents, of 1787, signed by a minority of the state's delegates, those who had voted against ratification of the Constitution, read that the people have a right to bear arms for the defense of themselves and their own state, or the United States, or for the purpose of killing game, and no law shall be passed for disarming the people or any of them unless for crimes committed, or real danger of public injury from individuals. And as standing armies in the time of peace are dangerous to liberty, they ought not to be kept up, and that the military shall be kept under strict subordination to and be governed by the civil powers. Finally, after the delegates at the Massachusetts Ratification Convention had compiled a list of proposed amendments and alterations, a motion was made to add to the list the following language: that the said Constitution be never construed to authorize Congress to prevent the people of the United States, who are peaceable citizens, from keeping their own arms. This motion, however, failed to achieve the necessary support, and the proposal was excluded from the list of amendments the state sent to Congress. Madison, charged with the task of assembling the proposals for amendments sent by the ratifying states, was the principal draftsman of the Second Amendment. He had before him, or at the very least would have been aware of, all of these proposed formulations. In addition, Madison had been a member some years earlier, of the committee tasked with drafting the Virginia Declaration of Rights. That committee considered a proposal by Thomas Jefferson that would have included within the Virginia Declaration the following language: no freeman shall ever be debarred the use of arms within his own lands or tenements. But the committee rejected that language, adopting instead the provision drafted by George Mason. With all of these sources upon which to draw, it is strikingly significant that Madison's first draft omitted any mention of non-military use or possession of weapons. Rather, his original draft repeated the essence of the two proposed amendments sent by Virginia, combining the substance of the two provisions succinctly into one, which read: the right of the people to keep and bear arms shall not be infringed, a well-armed and well-regulated militia being the best security of a free country, but no person religiously scrupulous of bearing arms shall be compelled to render military service in person. Madison's decision to model the Second Amendment on the distinctly military Virginia proposal is therefore revealing, since it is clear that he considered and rejected formulations that would have unambiguously protected civilian uses of firearms. When Madison prepared his first draft, and when that draft was debated and modified, it is reasonable to assume that all participants in the drafting process were fully aware of the other formulations that would have protected civilian use and possession of weapons, and that their choice to craft the amendment as they did represented a rejection of those alternative formulations. Madison's initial inclusion of an exemption for conscientious objectors sheds revelatory light on the purpose of the amendment. It confirms an intent to describe a duty as well as a right, and it unequivocally identifies the military character of both. The objections voiced to the conscientious objector clause only confirm the central meaning of the text. Although records of the debate in the Senate, which is where the conscientious objector clause was removed, do not survive, the arguments raised in the House illuminate the perceived problems with the clause. Specifically, there was concern that Congress can declare who are those religiously scrupulous and prevent them from bearing arms. The ultimate removal of the clause, therefore, only serves to confirm the purpose of the amendment: to protect against congressional disarmament by whatever means of the state's militias. The court also contends that because Quakers opposed the use of arms not just for militia service, but for any violent purpose whatsoever, the inclusion of a conscientious objector clause in the original draft of the amendment does not support the conclusion that the phrase bear arms was military in meaning. But that claim cannot be squared with the record. In the proposals cited above, both Virginia and North Carolina included the following language: that any person religiously scrupulous of bearing arms ought to be exempted upon payment of an equivalent to employ another to bear arms in his stead. Emphasis added. There is no plausible argument that the use of bear arms in those provisions was not unequivocally and exclusively military. The state simply does not compel its citizens to carry arms for the purpose of private confrontation or for self-defense. The history of the adoption of the amendment thus describes an overriding concern about the potential threat to state sovereignty that a federal standing army would pose, and a desire to protect the state's militias as the means by which to guard against that danger. But state militias could not effectively check the prospect of a federal standing army so long as Congress retained the power to disarm them, and so a guarantee against such disarmament was needed. As we explained in Miller, with obvious purpose to assure the continuation and render possible the effectiveness of such forces, the declaration and guarantee of the Second Amendment were made, it must be interpreted and applied with that end in view. The evidence plainly refutes the claim that the amendment was motivated by the framers' fears that Congress might act to regulate any civilian uses of weapons. And even if the historical record were genuinely ambiguous, the burden would remain on the parties advocating a change in the law to introduce facts or arguments newly ascertained. The court is unable to identify any such facts or arguments. Although it gives short shrift to the drafting history of the Second Amendment, the court dwells at length on four other sources: the 17th century English Bill of Rights, Blackstone's Commentaries on the Laws of England, post-enactment commentary on the Second Amendment, and post-Civil War legislative history. All of these sources shed only indirect light on the question before us, and in any event offer little support for the court's conclusion. The court's reliance on Article 7 of the 1689 English Bill of Rights, which, like most of the evidence offered by the court today, was considered in Miller, is misguided. Both because Article 7 was enacted in response to different concerns from those that motivated the framers of the Second Amendment, and because the guarantees of the two provisions were by no means coextensive. Moreover, the English text contained no preamble or other provision identifying a narrow militia-related purpose. The English Bill of Rights responded to abuses by the Stuart monarchs. Among the grievances set forth in the Bill of Rights was that the king had violated the law by causing several good subjects, being Protestants, to be disarmed at the same time when papists were both armed and employed contrary to law. Article 7 of the Bill of Rights was a response to that selective disarmament. It guaranteed that the subjects which are Protestants may have arms for their defense, suitable to their condition and as allowed by law. This grant did not establish a general right of all persons, or even of all Protestants, to possess weapons. Rather, the right was qualified in two distinct ways. First, it was restricted to those of adequate social and economic status, suitable to their condition. Second, it was only available subject to regulation by Parliament as allowed by law. The court may well be correct that the English Bill of Rights protected the right of some English subjects to use some arms for personal self-defense, free from restrictions by the Crown, but not Parliament. But that right, adopted in a different historical and political context and framed in markedly different language, tells us little about the meaning of the Second Amendment. Blackstone's Commentaries. The court's reliance on Blackstone's Commentaries on the Laws of England is unpersuasive for the same reason as its reliance on the English Bill of Rights. Blackstone's invocation of the natural right of resistance and self-preservation, and the right of having and using arms for self-preservation and defense, referred specifically to Article 7 of the English Bill of Rights. The excerpt from Blackstone offered by the court, therefore, is, like Article 7 itself, of limited use in interpreting the very differently worded and differently historically situated Second Amendment. What is important about Blackstone is the instruction he provided on reading the sort of text before us today. Blackstone described an interpretive approach that gave far more weight to preambles than the court allows, counseling that the fairest and most rational method to interpret the will of the legislature is by exploring his intentions at the time when the law was made, by signs the most natural and probable. Blackstone explained, if words happen to be still dubious, we may establish their meaning from the context, with which it may be of singular use to compare a word, or a sentence, whenever they are ambiguous, equivocal, or intricate. Thus, the proem, or preamble, is often called in to help the construction of an Act of Parliament. In light of the court's invocation of Blackstone as the preeminent authority on English law for the founding generation, its disregard for its guidance on matters of interpretation is striking. The court also excerpts, without any real analysis, commentary by a number of additional scholars, some near in time to the framing and others post-dating it by close to a century. Those scholars are for the most part of limited relevance in construing the guarantee of the Second Amendment. Their views are not altogether clear. They tended to collapse the Second Amendment with Article 7 of the English Bill of Rights, and they appear to have been unfamiliar with the drafting history of the Second Amendment. The most significant of these commentators was Joseph Story. Contrary to the court's assertions, however, Story actually supports the view that the amendment was designed to protect the right of each of the states to maintain a well-regulated militia. When Story used the term palladium in discussions of the Second Amendment, he merely echoed the concerns that animated the framers of the amendment and led to its adoption. An excerpt from his 1833 Commentaries on the Constitution of the United States, the same passage cited by the court in Miller, merits reproducing at some length. The importance of the Second Amendment will scarcely be doubted by any persons who have duly reflected upon the subject. The militia is the natural defense of a free country against sudden foreign invasions, domestic insurrections, and domestic usurpations of power by rulers. It is against sound policy for a free people to keep up large military establishments and standing armies in times of peace, both from the enormous expenses with which they are attended and the facile meaning which they afford to ambitious and unprincipled rulers to subvert the government or trample upon the rights of the people. The right of the citizens to keep and bear arms has justly been considered as the palladium of the liberties of a republic, since it offers a strong moral check against the usurpation and arbitrary power of rulers, and will generally, even if these are successful in the first instance, enable the people to resist and triumph over them. And yet, though this truth would seem so clear, and the importance of a well-regulated militia would seem so undeniable, it cannot be disguised that among the American people there is a growing indifference to any system of militia discipline, and a strong disposition from a sense of its burdens, to be rid of all regulations. How it is practicable to keep the people duly armed without some organization, it is difficult to see. There is certainly no small danger that indifference may lead to disgust, and disgust to contempt, and thus gradually undermine all the protection intended by the clause of our National Bill of Rights. Story thus began by tying the significance of the amendment directly to the paramount importance of the militia. He then invoked the fear that drove the framers of the Second Amendment, specifically the threat to liberty posed by a standing army. An important check on that danger, he suggested, was a well-regulated militia, for which he assumed that arms would have to be kept and, when necessary, borne. There is not so much as a whisper in the passage above that Story believed that the rights secured by the amendment bore any relation to private use or possession of weapons for activities like hunting or personal self-defense. After extolling the virtues of the militia as a bulwark against tyranny, Story went on to decry the growing indifference to any system of militia discipline, when he wrote how it is practicable to keep the people duly armed without some organization is difficult to see. He underscored the degree to which he viewed the arming of the people and the militia as indissolubly linked. Story warned that the growing indifference he perceived would gradually undermine all the protection intended by this clause of our National Bill of Rights. In his view, the importance of the amendment was directly related to the continuing vitality of an institution in the process of apparently becoming obsolete. In an attempt to downplay the absence of any reference to non-military uses of weapons in Story's commentary, the court relies on the fact that Story characterized Article 7 of the English Declaration of Rights as a similar provision. The two provisions were indeed similar, in that both protected some uses of firearms, but Story's characterization in no way suggests that he believed that the provisions had the same scope. To the contrary, Story's exclusive focus on the militia in his discussion of the Second Amendment confirms his understanding of the right protected by the Second Amendment as limited to military uses of arms. Story's writing that as a justice of this court, to the extent that they shed light on this question, only confirms that Justice Story did not view the amendment as conferring upon individuals any self-defense right disconnected from service in a state militia. Justice Story dissented from the court's decision in Houston v. Moore. which held that a state court had a concurrent jurisdiction with the federal courts to try a militiaman who had disobeyed the call of the president and to enforce the laws of Congress against such delinquent. Justice Story believed that Congress's power to provide for the organizing, arming, and disciplining of the militia was when Congress acted plenary, but he explained that in the absence of congressional action, I am certainly not prepared to deny the legitimacy of such an exercise of state authority. As to the Second Amendment, he wrote that it may not perhaps be thought to have any important bearing on this point. If it have, it confirms and illustrates. If it have, it confirms and illustrates rather than impugns the reasoning already suggested. The court contends that had Justice Story understood the amendment to have a militia purpose, the amendment would have had enormous and obvious bearing on the point. But the court has it quite backwards. If Story had believed that the purpose of the amendment was to permit civilians to keep firearms for activities like personal self-defense, what confirmation and illustration could the amendment possibly have provided for the point that states retained the power to organize, arm, and discipline their own militias? Post-Civil War legislative history. The court suggests that by the post-Civil War period, the Second Amendment was understood to secure a right to firearm use and ownership for purely private purposes like personal self-defense. While it is true that some of the legislative history on which the court relies supports that contention, such sources are entitled to limited, if any, weight. All of the statements the court cites were made long after the framing of the amendment and cannot possibly supply any insight into the intent of the framers, and all were made during pitched political debates, so that they are better characterized as advocacy than good faith attempts at constitutional interpretation. What is more, much of the evidence the court offers is decidedly less clear than its discussion allows. The court notes, blacks were routinely disarmed by southern states after the Civil War. Those who opposed these injustices frequently stated that they infringed blacks' constitutional right to keep and bear arms. The court hastily concludes that, needless to say, the claim was not that blacks were being prohibited from carrying arms in an organized state militia, but some of the claims of the sort the court cites may have been just that. In some southern states, Reconstruction-era Republican governments created state militias in which both blacks and whites were permitted to serve. Because the decision to allow blacks to serve alongside whites meant that most Southerners refused to join the new militia, the bodies were dubbed African American militias. The arming of the African American militias met with especially fierce resistance in South Carolina. The sight of organized armed freedmen incensed opponents of Reconstruction and led to an intensified campaign of Klan terror. Leading members of the African American militia were beaten or lynched and their weapons stolen. One particularly chilling account of Reconstruction-era Klan violence directed at a black militia member is recounted in the memoir of Lewis F. Post, a carpetbagger in South Carolina. Post describes the murder of local Klan members of Jim Williams, the captain of an African-American militia company, this way. A cavalcade of 60 cowardly white men, completely disguised with face masks and body gowns, rode up one night in March 1871 to the house of Captain Williams. In the wood, they hanged and shot him. On his body they pinned a slip of paper inscribed, as I remember it, with these grim words: "Jim Williams gone to his last muster." In light of this evidence, it is quite possible that at least some of the statements on which the court relies actually did mean to refer to the disarmament of black militia members. The brilliance of the debates that resulted in the Second Amendment faded into oblivion during the ensuing years, for the concerns about Article I's militia clauses that generated such pitched debate during the ratification process and led to the adoption of the Second Amendment were short-lived. In 1792, the year after the amendment was ratified, Congress passed a statute that purported to establish a uniform militia throughout the United States. The statute commanded every able-bodied white male citizen between the ages of 18 and 45 to be enrolled therein and to provide himself with a good musket or firelock and other specified weaponry. The statute is significant, for it confirmed the way those in the founding generation viewed firearm ownership, as a duty linked to military service. The statute they enacted, however, was virtually ignored for more than a century, and was finally repealed in 1901. The post-ratification history of the Second Amendment is strikingly similar. The amendment played little role in any legislative debate about the civilian use of firearms for most of the 19th century, and it made few appearances in the decisions of this court. Two 19th century cases, however, bear mentioning. In United States v. Cruikshank, the court sustained a challenge to respondents' convictions under the Enforcement Act of 1870 for conspiring to deprive any individual of any right or privilege granted or secured to him by the Constitution or laws of the United States. The court wrote, as to counts 2 and 10 of respondent's indictment, the right there specified is that of bearing arms for a lawful purpose. That is not a right granted by the Constitution. Neither is it in any manner dependent on that instrument for its existence. The Second Amendment declares that it shall not be infringed, but this, as has been seen, means no more than it shall not be infringed by Congress. This is one of the amendments that has no other effect than to restrict the powers of the national government. The majority's assertion that the court in Cruikshank described the right protected by the Second Amendment as bearing arms for a lawful purpose is not accurate. The Cruikshank court explained that the defective indictment contained such language, but the court did not itself describe the right or endorse the indictment's description of the right. Moreover, it is entirely possible that the basis for the indictment's counts 2 and 10, which charged respondents with depriving the victims of rights secured by the Second Amendment, was the prosecutor's belief that the victims, members of a group of citizens, mostly black but also white, who were rounded up by the sheriff, sworn in as a posse to defend the local courthouse, and attacked by a white mob, bore sufficient resemblance to members of a state militia that they were brought within the reach of the Second Amendment. Only one other 19th century case in this court, Presser v. Illinois, engaged in any significant discussion of the Second Amendment. The petitioner in Presser was convicted of violating a state statute that prohibited organizations other than the Illinois National Guard from associating together as military companies or parading with arms. Presser challenged his conviction, asserting as relevant that the statute violated both the Second and the 14th Amendments. With respect to the Second Amendment, the court wrote, "We think it clear that the section under consideration, which only forbids bodies of men to associate together as military organizations or to drill or parade with arms in cities and towns unless authorized by law, do not infringe the right of the people to keep and bear arms. But a conclusive answer to the contention that this amendment prohibits the legislation in question lies in the fact that the amendment is a limitation only upon the power of Congress and the national government, and not upon that of the states." And in discussing the 14th Amendment, the court explained, "The plaintiff in error was not a member of the organized volunteer militia of the state of Illinois, nor did he belong to the troops of the United States or to any organization under the militia law of the United States. On the contrary, the fact that he did not belong to the organized militia or the troops of the United States was an ingredient in the offense for which he was convicted and sentenced. The question is therefore, had he a right as a citizen of the United States, in disobedience of the state law, to associate with others as a military company and to drill and parade with arms in the towns and cities of the state? If the plaintiff in error has any such privilege, he must be able to point to the provision of the Constitution or statutes of the United States by which it is conferred." Presser therefore both affirmed Cruikshank's holding that the Second Amendment posed no obstacle to regulation by state governments, and suggested that in any event, nothing in the Constitution protected the use of arms outside the context of a militia authorized by law and organized by the state or federal government. In 1901, the president revitalized the militia by creating the National Guard of the several states. Meanwhile, the dominant understanding of the Second Amendment's inapplicability to private gun ownership continued well into the 20th century. The first two federal laws directly restricting civilian use and possession of firearms, the 1927 Act prohibiting mail delivery of pistols, revolvers, and other firearms capable of being concealed on the person, and the 1934 Act prohibiting the possession of sawed-off shotguns and machine guns, were enacted over minor Second Amendment objections dismissed by the vast majority of the legislators who participated in the debates. Members of Congress clashed over the wisdom and efficacy of such laws as crime control measures. But since the statutes did not infringe upon the military use or possession of weapons, for most legislators, they did not even raise the specter of possible conflict with the Second Amendment. Thus, for most of our history, the invalidity of Second Amendment-based objections to firearms regulations has been well settled and uncontroversial. Indeed, the Second Amendment was not even mentioned in either full House of Congress during the legislative proceedings that led to the passage of the 1934 Act. Yet enforcement of that law produced the judicial decision that confirmed the status of the amendment as limited in reach to military usage. After reviewing many of the same sources that are discussed at greater length by the court today, the Miller Court unanimously concluded that the Second Amendment did not apply to the possession of a firearm that did not have some reasonable relationship to the preservation or efficiency of a well-regulated militia. The key to that decision did not, as the court belatedly suggests, turn on the difference between muskets and sawed-off shotguns. It turned, rather, on the basic difference between the military and non-military use and possession of guns. Indeed, if the Second Amendment were not limited to its coverage to military uses of weapons, why should the court in Miller have suggested that some weapons, but not others, were eligible for Second Amendment protection? If use for self-defense were the relevant standard, why did the court not inquire into the suitability of a particular weapon for self-defense purposes? Perhaps in recognition of the weakness of its attempt to distinguish Miller, the court argues in the alternative that Miller should be discounted because of its decisional history. It is true that the appellees in Miller did not file a brief or make an appearance. Although the court below had held that the relevant provision of the National Firearms Act violated the Second Amendment, albeit without any reasoned opinion, but, as our decision in Marbury v. Madison, in which only one side appeared and presented arguments, demonstrates, the absence of adversarial presentation alone is not a basis for refusing to accord stare decisis effect to a decision of this court. Of course, if it can be demonstrated that new evidence or arguments were genuinely not available to an earlier court, that fact should be given special weight as we consider whether to overrule a prior case. But the court does not make that claim because it cannot. Although it is true that the drafting history of the amendment was not discussed in the government's brief, it is certainly not the drafting history that the court's decision today turns on, and those sources upon which the court today relies most heavily were available to the Miller Court. The government cited the English Bill of Rights and quoted a lengthy passage from Amet v. State, detailing the history leading to the English guarantee. It also cited Blackstone and Story. The court is reduced to critiquing the number of pages the government devoted to exploring the English legal sources. Only two, in a brief 21 pages in length, would the court be satisfied with 4? 10? The court is simply wrong when it intones that Miller contained not a word about the amendment's history. The court plainly looked to history to construe the term militia, and, on the best reading of Miller, the entire guarantee of the Second Amendment, after noting the original Constitution's grant of power to Congress and to the states over the militia, the court explained. With obvious purpose to assure the continuation and render possible the effectiveness of such forces, the declaration and guarantee of the Second Amendment were made. It must be interpreted and applied with that end in view. The militia, which the states were expected to maintain and train, is set in contrast with troops which they were forbidden to keep without the consent of Congress. The sentiment of the time strongly disfavored standing armies. The common view was that adequate defense of country and laws could be secured through the militia, civilians primarily, soldiers on occasion. The signification attributed to the term militia appears from the debates in the convention, the history and legislation of colonies and states, and the writings of approved commentators. The majority cannot seriously believe that the Miller Court did not consider any relevant evidence. The majority simply does not approve of the conclusion the Miller Court reached on that evidence. Standing alone, that is insufficient reason to disregard a unanimous opinion of this court upon which substantial reliance has been placed by legislators and citizens for nearly 70 years. The court concludes its opinion by declaring that it is not the proper role of this court to change the meaning of rights enshrined in the Constitution. But the right the court announces was not enshrined in the Second Amendment by the framers. It is the product of today's law-changing decision. The majority's exegesis has utterly failed to establish that as a matter of text or history, the right of law-abiding, responsible citizens to use arms in defense of hearth and home is elevated above all other interests by the Second Amendment. Until today, it has been understood that legislatures may regulate the civilian use and misuse of firearms so long as they do not interfere with the preservation of a well-regulated militia. The court's announcement of a new constitutional right to own and use firearms for private purposes upsets that settled understanding, but leaves for future cases the formidable task of defining the scope of permissible regulations. Today, judicial craftsmen have confidently asserted that a policy choice that denies a law-abiding responsible citizen the right to keep and use weapons in the home for self-defense is off the table. Given the presumption that most citizens are law-abiding and the reality that the need to defend oneself may suddenly arise in a host of locations outside the home, I fear that the district's policy choice may well be just the first of an unknown number of dominoes to be knocked off the table. I do not know whether today's decision will increase the labor of federal judges to the breaking point envisioned by Justice Cardozo, but it will surely give rise to a far more active judicial role in making vitally important national policy decisions than was envisioned at any time in the 18th, 19th, or 20th centuries. The court properly disclaims any interest in evaluating the wisdom of the specific policy choice challenged in this case, but it fails to pay heed to a far more important policy choice, the choice made by the framers themselves. The court would have us believe that over 200 years ago, the framers made a choice to limit the tools available to elected officials wishing to regulate civilian uses of weapons and to authorize this court to use the common law process of case-by-case judicial lawmaking to define the contours of acceptable gun control policy. Absent compelling evidence that is nowhere to be found in the court's opinion, I could not possibly conclude that the framers made such a choice. For these reasons, I respectfully dissent. Justice Breyer, with whom Justice Stevens, Justice Souter, and Justice Ginsburg joined dissenting, we must decide whether a District of Columbia law that prohibits the possession of handguns in the home violates the Second Amendment. The court, relying upon its view that the Second Amendment seeks to protect a right of personal self-defense, holds that this law violates that amendment. In my view, it does not. The majority's conclusion is wrong for two independent reasons. The first is that set forth by Justice Stevens, namely that the Second Amendment protects militia-related, not self-defense-related interests. These two interests are sometimes intertwined. To assure 18th century citizens that they could keep arms for militia purposes would necessarily have allowed them to keep arms that they could have used for self-defense as well. But self-defense alone, detached from any militia-related objective, is not the amendment's concern. The second independent reason is that the protection the amendment provides is not absolute. The amendment permits government to regulate the interests that it serves. Thus, irrespective of what those interests are, whether they do or do not include an independent interest in self-defense, the majority's view cannot be correct unless it can show that the district's regulation is unreasonable or inappropriate in the Second Amendment terms. This the majority cannot do. In respect to the first independent reason, I agree with Justice Stevens and I join his opinion. In this opinion, I shall focus upon the second reason. I shall show that the district's law is consistent with the Second Amendment, even if that amendment is interpreted as protecting a wholly separate interest in individual self-defense. That is so because the district's regulation, which focuses upon the presence of handguns in high-crime urban areas, represents a permissible legislative response to a serious, indeed life-threatening problem. Thus, I here assume that one objective, but as the majority concedes earlier, not the primary objective, of those who wrote the Second Amendment was to help assure citizens that they would have arms available for purposes of self-defense. Even so, a legislature could reasonably conclude that the law will advance goals of great public importance, namely saving lives, preventing injury, and reducing crime. The law is tailored to the urban crime problem in that it is local in scope and thus affects only a geographic area, both limited in size and entirely urban. The law concerns handguns, which are specially linked to urban gun deaths and injuries, and which are the overwhelmingly favorite weapon of armed criminals. And at the same time, the law imposes a burden upon gun owners that seems proportionately no greater than restrictions in existence at the time the Second Amendment was adopted. In these circumstances, the district's law falls within the zone that the Second Amendment leaves open to regulation by legislatures. The Second Amendment says, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." In interpreting and applying this amendment, I take as a starting point the following four propositions, based on our precedent and today's opinions, to which I believe the entire court subscribes. The amendment protects an individual right, for example, one that is separately possessed and may be separately enforced by each person on whom it is conferred. Two, as evidenced by its preamble, the amendment was adopted with obvious purpose to assure the continuation and render possible the effectiveness of militia forces. The amendment must be interpreted and applied with that end in view. The right protected by the Second Amendment is not absolute, but instead is subject to government regulation. My approach to this case, while involving the first 3 points, primarily concerns the fourth. I shall, as I said, assume that with the majority that the amendment, in addition to furthering a militia-related purpose, also furthers an interest in possessing guns for purposes of self-defense, at least to some degree. And I shall then ask whether the amendment nevertheless permits the district handgun restriction at issue here. Although I adopt for present purposes the majority's position that the Second Amendment embodies a general concern about self-defense, I shall not assume that the amendment contains a specific untouchable right to keep guns in the house to shoot burglars. The majority, which presents evidence in favor of the former proposition, does not, because it cannot, convincingly show that the Second Amendment seeks to maintain the latter in pristine, unregulated form. To the contrary, colonial history itself offers important examples of the kind of gun regulation that citizens would then have thought compatible with the right to keep and bear arms, whether embodied in federal or state constitutions or the background common law. And those examples include substantial regulations of firearms in urban areas, including regulations that imposed obstacles to the use of firearms for the protection of the home. Boston, Philadelphia, and New York City, the 3 largest cities in America during that period, all restricted the firing of guns within city limits to at least some degree. Boston in 1746 had a law prohibiting the discharge of any gun or pistol charged with shot or ball in the town on penalty of 40 shillings, a law that was later revived in 1778. Philadelphia prohibited on penalty of 5 shillings or 2 days in jail if the fine were not paid, firing a gun or setting off fireworks in Philadelphia without a governor's special license. And New York City banned on penalty of a 20-shilling fine the firing of guns even in houses for the 3 days surrounding New Year's Day. Furthermore, several towns and cities, including Philadelphia, New York, and Boston, let me back up. Similar law for all inhabiting parts of Pennsylvania. See also here. See also an act for preventing mischief being done in the town of Newport or in any town or in any other town in this government. For example, 1731 Rhode Island Session laws prohibiting on penalty of 5 shillings for a first offense and more for subsequent offenses the firing of any gun or pistol in the streets of any of the towns of this government or in any tavern of the same after dark on any night whatsoever. Furthermore, several towns and cities, including Philadelphia, New York, and Boston, regulated for fire safety reasons the storage of gunpowder, a necessary component of an operational firearm. Boston's law, in particular, impacted the use of firearms in the home very much as the district's law does today. Boston's gunpowder law imposed a 10-pound fine upon any person who shall take into any dwelling house, stable, barn, outhouse, warehouse, store, shop, or other building within the town of Boston any firearm loaded with or having gunpowder, an action in addition to the several acts already made for the prudent storage of gunpowder within the town of Boston. Even assuming as the majority does that this law included an implicit self-defense exception, it would nevertheless have prevented a homeowner from keeping in his home a gun that he could immediately pick up and use against an intruder. Rather, the homeowner would have had to get the gunpowder and load it into the gun, an operation that would have taken a fair amount of time to perform. Experienced soldier could, with specially prepared cartridges as opposed to plain gunpowder and ball, load and fire a musket 3 to 4 times per minute. Moreover, the law would, as a practical matter, have prohibited the carrying of loaded firearms anywhere in the city unless the carrier had no plans to enter any building or was willing to unload or discard his weapons before going inside. And Massachusetts residents must have believed this kind of law compatible with the provision in the Massachusetts Constitution that granted the people a right to keep and to bear arms for the common defense, a provision that the majority says was interpreted as securing an individual right to bear arms for defensive purposes. The New York City law, which required that gunpowder in the home be stored in certain sorts of containers, and laws in certain Pennsylvania towns, which required that gunpowder be stored on the highest story of the home, could well have presented similar obstacles to in-home use of firearms. Although it is unclear whether these laws, like the Boston law, would have prohibited the storage of gunpowder inside a firearm, they would have, at the very least, have made it difficult to reload the gun to fire a second shot unless the homeowner happened to be in the portion of the house where the extra gunpowder was required to be kept. Until 1835, all small arms were single-shot weapons requiring reloading by hand after every shot. And Pennsylvania, like Massachusetts, had at the time one of the self-defense guaranteeing state constitutional provisions on which the majority relies. The majority criticizes my citation of these colonial laws, but as much as it tries, it cannot ignore their existence. I suppose it is possible that, as the majority suggests, they all in practice contained self-defense exceptions, but none of them expressly provided one, and the majority's assumption that such exceptions existed relies largely on the preambles to these acts, an interpretive methodology that is elsewhere roundly derided. And in any event, as I have shown, the gunpowder storage laws would have burdened armed self-defense, even if they did not completely prohibit it. This historical evidence demonstrates that a self-defense assumption is the beginning, rather than the end, and of any constitutional inquiry. That the district law impacts self-defense merely raises questions about the law's constitutionality, but to answer the questions that are raised, that is, to see whether the statute is unconstitutional, requires us to focus on practicalities, the statute's rationale, the problems that called it into being, its relation to those objectives, in a word, the details. There are no purely logical or conceptual answers to such questions, all of which to say that to raise a self-defense question is not to answer it. I therefore begin by asking a process-based question. How is a court to determine whether a particular firearm regulation, here the district's restriction on handguns, is consistent with the Second Amendment? What kind of constitutional standards should the court use? How high a protective hurdle does the amendment erect? The question matters. The majority is wrong when it says that the district's law is unconstitutional under any of the standards of scrutiny that we have applied to enumerated constitutional rights. How could that be? It certainly would not be unconstitutional under, for example, a rational basis standard, which requires a court to uphold regulation so long as it bears a rational relationship to a legitimate governmental purpose. The law at issue here, which in part seeks to prevent gun-related accidents, at least bears a rational relationship to that legitimate life-saving objective. And nothing in the three 19th century state cases to which the majority turns for support mandates the conclusion that the present district law must fall. These cases were decided 80, 55, and 49 years respectively after the framing. Actually, let me back up. District's law must fall. See Andrews v. State, striking down as violating a state constitutional provision adopted in 1870, a statewide ban on carrying a broad class of weapons insofar as it applied to revolvers. Nunn v. State, striking down similarly broad ban on openly carrying weapons based on erroneous view that the federal Second Amendment applied to the states. And then State v. Reed, upholding a concealed weapon ban against a state constitutional challenge. These cases were decided 80, 55, and 49 years respectively after the framing. They neither claim nor provide any special insight into the intent of the framers. They involve laws much less narrowly tailored than the one before us, and state cases, in any event, are not determinative of federal constitutional questions. Respondent proposes that the court adopt a strict scrutiny test, which would require reviewing with care each gun law to determine whether it is narrowly tailored to achieve a compelling governmental interest. But the majority implicitly and appropriately rejects that suggestion by broadly approving a set of laws, prohibitions on concealed weapons, forfeiture by criminals of the Second Amendment right, prohibitions on firearms in certain locales, and governmental regulation of commercial firearms sales, whose constitutionality under strict scrutiny standard would be far from clear. Indeed, adoption of a true strict scrutiny standard for evaluating gun regulations would be impossible. That is because almost every gun control regulation will seek to advance, as the one here does, a primary concern of every government, a concern for the safety and indeed the lives of its citizens. The court has deemed that interest, as well as the government's general interest in preventing crime, to be compelling, and the court has, in a wide variety of constitutional contexts, found such public safety concerns sufficiently forceful to justify restrictions on individual liberties. For example, Brandenburg v. Ohio, First Amendment free speech rights, Sherbert v. Werner, First Amendment religious rights, Brigham City v. Stewart, Fourth Amendment protection of the home, New York v. Quarles, Fifth Amendment rights under Miranda v. Arizona, Salerno above, Eighth Amendment bail rights. Thus, any attempt in theory to apply strict scrutiny to gun regulations will in practice turn into an interest balancing inquiry, with the interests protected by the Second Amendment on one side and the governmental public safety concerns on the other. The only question being whether the regulation at issue impermissibly burdens the former in the course of advancing the latter. I would simply adopt such an interest balancing inquiry explicitly. The fact that important interests lie on both sides of the constitutional equation suggests that review of gun control regulation is not a context in which a court should effectively presume either constitutionality, as in rational basis review, or unconstitutionality, as in strict scrutiny. Rather, where a law significantly implicates competing constitutionally protected interests in complex ways, the court generally asks whether the statute burdens a protected interest in a way or to an extent that is out of proportion to the statute's salutary effects upon other important governmental interests. Any answer would take account both of the statute's effects upon the competing interests and the existence of any clearly superior, less restrictive alternative. Contrary to the majority's unsupported suggestion that this sort of proportionality approach is unprecedented, the court has applied it in various constitutional contexts, including election law cases, speech cases, and due process cases. In applying this kind of standard, the court normally defers to a legislature's empirical judgment in matters where a legislature is likely to have greater expertise and greater institutional fact-finding capacity. Nonetheless, a court, not a legislature, must make the ultimate constitutional conclusion, exercising its independent judicial judgment in light of the whole record to determine whether a law exceeds constitutional boundaries. The above described approach seems preferable to a more rigid approach here for a further reason. Experience, as much as logic, has led the court to decide that in one area of constitutional law or another, the interests are likely to prove stronger on one side of a typical constitutional case than on the other. See United States v. Virginia, applying heightened scrutiny to gender-based classifications based upon experience with prior cases, and Williamson v. Lee Optical, applying rational basis scrutiny to economic legislation based upon experience with prior cases. Here we have little prior experience. Courts that do have experience in these matters have uniformly taken an approach that treats empirically based legislative judgment with a degree of deference. While these state cases obviously are not controlling, they are instructive. For example, Bartkus v. Illinois, looking to the experience of state courts as informative of a constitutional question, and they thus provide some comfort regarding the practical wisdom of following the approach that I believe our constitutional precedent would in any event suggest. The present suit involves challenges to three separate district firearm restrictions. The first requires a license from the district's chief of police in order to carry a pistol, for example a handgun, anywhere in the district. Because the district assures us that respondent could obtain such a license so long as he meets the statutory eligibility criteria, and because respondent concedes that those criteria are facially constitutional, I, like the majority, see no need to address the constitutionality of the licensing requirement. The second district restriction requires that the lawful owner of a firearm keep his weapon unloaded and disassembled or bound by a trigger lock or similar device, unless it is kept at his place of business or being used for lawful recreational purposes. The only dispute regarding this provision appears to be whether the Constitution requires an exception that would allow someone to render a firearm operational when necessary for self-defense. For example, that the firearm may be operated under circumstances where the common law would normally permit a self-defense justification in defense against a criminal charge. The district concedes that such an exception exists. This court has final authority, albeit not often used, to definitively interpret district law, which is, after all, simply a species of federal law. And because I see nothing in the district law that would preclude the existence of a background common law self-defense exception, I would avoid the constitutional question by interpreting the statute to include it. I am puzzled by the majority's unwillingness to adopt a similar approach. It readily reads unspoken self-defense exceptions into every colonial law, but it refuses to accept the district's concession that this law has one. The one district case it cites to support that refusal, McIntosh v. Washington, merely concludes that the district legislature had a rational basis for applying the trigger lock law in homes but not in places of business. Nowhere does that case say that the statute precludes a self-defense exception of the sort that I have just described. And even if it did, we are not bound by a lower court's interpretation of federal law. The third district restriction prohibits, in most cases, the registration of a handgun within the district. Because registration is a prerequisite to firearm possession, the effect of this provision is generally to prevent people in the district from possessing handguns. In determining whether this regulation violates the Second Amendment, I shall ask how the statute seeks to further the governmental interests that it serves, how the statute burdens the interests that the Second Amendment seeks to protect, and whether there are practical, less burdensome ways of furthering those interests. The ultimate question is whether the statute imposes burdens that, when viewed in light of the statute's legitimate objectives, are disproportionate. No one doubts the constitutional importance of the statute's basic objective, saving lives, but there is considerable debate about whether the district statute helps to achieve that objective. I begin by reviewing the statute's tendency to secure that objective from the perspective of 1. The legislature, namely the Council of the District of Columbia, hereinafter Council, that enacted the statute in 1976, and 2. A court that seeks to evaluate the Council's decision today. First, consider the facts as the legislature saw them when it adopted the district's statute. As stated by the local council committee that recommended its adoption, the major substantive goal of the district's handgun restriction is to reduce the potentiality for gun-related crimes and gun-related deaths from occurring within the District of Columbia. The committee concluded, on the basis of extensive public hearings and lengthy research, that the easy availability of firearms in the United States has been a major factor contributing to the drastic increase in gun-related violence and crime over the past 40 years. It reported to the Council startling statistics regarding gun-related crimes, accidents, and deaths, focusing particularly on the relation between handguns and the crime and the proliferation of handguns within the district. The committee informed the Council that guns were responsible for 69 deaths in this country each day, for a total of approximately 25,000 gun deaths each year, along with an additional 200,000 gun-related injuries. 3,000 of these deaths, the report stated, were accidental. A quarter of the victims in those accidental deaths were children under the age of 14, and according to the committee, for every intruder stopped by a homeowner with a firearm, there are 4 gun-related accidents within the home. In respect to local crime, the committee observed that there were 285 murders in the district during 1974, a record number. The committee also stated that, contrary to popular opinion on the subject, firearms are more frequently involved in deaths and violence among relatives and friends than in premeditated criminal activities. Citing an article from the American Journal of Psychiatry, the committee reported that most murders are committed by previously law-abiding citizens in situations where spontaneous violence is generated by anger, passion, or intoxication, and where the killer and victim are acquainted. 25% of these murders, the committee informed the council, occur within families. The committee report furthermore presented statistics strongly correlating handguns with crime. Of the 285 murders in the district in 1974, 155 were committed with a handgun. This did not appear to be an aberration, as the report revealed that handguns have been used in roughly 54% of all murders, and 87% of murders of law enforcement officers nationwide over the preceding several years. Nor were handguns only linked to murders, as statistics showed that they were used in roughly 60% of robberies and 26% of assaults. A crime committed with a pistol, the committee reported, is 7 times more likely to be lethal than a crime committed with any other weapon. The committee furthermore presented statistics regarding the availability of handguns in the United States, and noted that they had become easy for juveniles to obtain, even despite then current district laws prohibiting juveniles from possessing them. In the committee's view, the current district firearms laws were unable to reduce the potentiality for gun-related violence or to cope with the problems of gun control in the district more generally. In the absence of adequate federal gun legislation, the committee concluded it becomes necessary for local governments to act to protect their citizens, and certainly the District of Columbia, as the only totally urban state-like jurisdiction, should be strong in its approach. It recommended that the council adopt a restriction on handgun registration to reflect a legislative decision that, at this point in time and due to the gun-controlled tragedies and horrors enumerated previously in the committee report, pistols are no longer justified in this jurisdiction. Handgun restriction denotes a policy decision that handguns have no legitimate use in the purely urban environment of the district. The district's special focus on handguns thus reflects the fact that the committee report found them to have a particularly strong link to undesirable activities in the district's exclusively urban environment. The district did not seek to prohibit possession of other sorts of weapons deemed more suitable for an urban area. Indeed, an original draft of the bill and the original committee recommendations had sought to prohibit registration of shotguns as well as handguns, but the council as a whole decided to narrow the prohibition. Next, consider the facts as a court must consider them, looking at the matter as of today. Petitioners and their amici have presented us with more recent statistics that tell much the same story that the committee report told 30 years ago. At the least, they present nothing that would permit us to second-guess the council in respect to the numbers of gun crimes, injuries, and deaths, or the role of handguns. From 1993 to 1997, there were 180,533 firearm-related deaths in the United States, an average of over 36,000 per year. 51% were suicides, 44% were homicides, 1% were legal interventions, 3% were unintentional accidents, and 1% were of undetermined causes. Over that same period, there were an additional 411,800 non-fatal firearm-related injuries treated in U.S. hospitals, an average of over 82,000 per year. Of these, 62% resulted from assaults, 17% were unintentional, 6% were suicide attempts, 1% were legal interventions, and 13% were of unknown causes. The statistics are particularly striking in respect to children and adolescents. In over one in every 8 firearm-related deaths in 1997, the victim was someone under the age of 20. Firearm-related deaths account for 22.5% of all injury deaths between the ages of 1 and 19. More male teenagers die from firearms than from all natural causes combined. Persons under 25 accounted for 47% of hospital-treated firearm injuries between June 1, 1992 and May 31, 1993. Handguns are involved in a majority of firearm deaths and injuries in the United States. From 1993 to 1997, 81% of firearm homicide victims were killed by handgun. In the same period, for the 41% of firearm injuries for which the weapon type is known, 82% of them were from handguns. And among children under the age of 20, handguns account for approximately 70% of all unintentional firearm related injuries and deaths. In particular, 70% of all firearm related teenage suicides in 1996 involved a handgun. Handguns also appear to be a very popular weapon among criminals. In a 1997 survey of inmates who were armed during the crime for which they were incarcerated, 83.2% of state inmates and 86.7% of federal inmates said that they were armed with a handgun. And handguns are not only popular tools for crime, but popular objects of it as well. The Federal Bureau of Investigation received, on average, over 274,000 reports of stolen guns for each year between 1985 and 1994, and almost 60% of stolen guns are handguns. Department of Justice studies have concluded that stolen handguns, in particular, are an important source of weapons for both adult and juvenile offenders. Statistics further suggest that urban areas, such as the district, have different experiences with gun-related death, injury, and crime than do less densely populated rural areas. A disproportionate amount of violent and property crimes occur in urban areas, and urban criminals are more likely than other offenders to use a firearm during the commission of a violent crime. Homicide appears to be a much greater issue in urban areas. From 1985 to 1993, for example, half of all homicides occurred in 63 cities with 16% of the nation's population. One study concluded that although the overall rate of gun death between 1989 and 1999 was roughly the same in urban and rural areas, the urban homicide rate was 3 times as high. Even after adjusting for other variables, it was still twice as high. And a study of firearm injuries to children and adolescents in Pennsylvania between 1987 and 2000 showed an injury rate in urban counties 10 times higher than in non-urban counties. Finally, the linkage of handguns to firearm deaths and injuries appears to be much stronger in urban than in rural areas. Studies to date generally support the hypothesis that the greater number of rural gun deaths are from rifles or shotguns, whereas the greater number of urban gun deaths are from handguns. And the Pennsylvania study reached a similar conclusion with respect to firearm injuries. They are much more likely to be caused by handguns in urban areas than in rural areas. Respondent and his many amici, for the most part, do not disagree about the figures set forth in the preceding subsection, but they do disagree strongly with the district's predictive judgment that a ban on handguns will help solve the crime and accident problems that those figures disclose. In particular, they disagree with the district council's assessment that freezing the pistol population within the district will reduce crime, accidents, and deaths related to guns, and they provide facts and figures designed to show that it has not done so in the past and hence will not do so in the future. First, they point out that since the ban took effect, violent crime in the district has increased, not decreased. Indeed, a comparison with 49 other major cities reveals that the district's homicide rate is actually substantially higher relative to these other cities than it was before the handgun restriction went into effect. Respondents amici report similar results in comparing the district's homicide rates during that period to that of the neighboring states of Maryland and Virginia, neither of which restricts handguns to the same degree, and to the homicide rate of the nation as a whole. Second, respondents amici point to a statistical analysis that regresses murder rates against the presence or absence of strict gun laws in 20 European nations. That analysis concludes that stricter gun laws are correlated with more murders, not fewer. They also cite domestic studies based on data from various cities, states, and the nation as a whole, suggesting that a reduction in the number of guns does not lead to a reduction in the amount of violent crime. They further argue that handgun bans do not reduce suicide rates or rates of accidents, even those involving children. Third, they point to evidence indicating that firearm ownership does have a beneficial self-defense effect. Based on a 1993 survey, the authors of one study estimated that there were 2.2 to 2.5 million defensive uses of guns, mostly brandishing, about a quarter involving the actual firing of a gun annually. Another study estimated that for a period of 12 months ending in 1994, there were 503,481 incidents in which a burglar found himself confronted by an armed homeowner, and that In 497,646, 98.8% of them, the intruder was successfully scared away. A third study suggests that gun-armed victims are substantially less likely than non-gun-armed victims to be injured in resisting robbery or assault. And additional evidence suggests that criminals are likely to be deterred from burglary and other crimes if they know the victim is likely to have a gun. Fourth, respondents amici argue that laws criminalizing gun possession are self-defeating, as evidence suggests that they will have the effect only of restricting law-abiding citizens, but not criminals from acquiring guns. That effect, they argue, will be especially pronounced in the district, whose proximity to Virginia and Maryland will provide criminals with a steady supply of guns. In the view of respondents amici, this evidence shows that other remedies, such as less restriction on gun ownership or liberal authorization of law-abiding citizens to carry concealed weapons, better fit the problem. They further suggest that, at a minimum, the district fails to show that its remedy, the gun ban, bears reasonable relation to the crime and accident problems that the district seeks to solve. These empirically based arguments may have proved strong enough to convince many legislatures as a matter of legislative policy not to adopt total handgun bans. But the question here is whether they are strong enough to destroy judicial confidence in the reasonableness of a legislature that rejects them, and that they are not. For one thing, they can lead us more deeply into the uncertainties that surround any effort to reduce crime, but they cannot prove either that handgun possession diminishes crime or that handgun bans are ineffective. The statistics do show a soaring district crime rate, and the district's crime rate went up after the district adopted its handgun ban. But as students of elementary logic know, after it does not mean because of it. What would the district's crime rate have looked like without the ban? Higher, lower, the same? Experts differ, and we as judges cannot say. What about the fact that foreign nations with strict gun laws have higher crime rates? Which is the cause and which is the effect? The proposition that strict gun laws cause crime is harder to accept than the proposition that strict gun laws, in part, grow out of the fact that a nation already has a higher crime rate. And we are then left with the same question as before. What would have happened to crime without the gun laws? A question that respondent and his amici do not convincingly answer. Further, suppose the respondents amici are right when they say that householders' possession of loaded handguns help to frighten away intruders. On that assumption, one must still ask whether that benefit is worth the potential death-related cost, and that is a question without a directly provable answer. Finally, consider the claim of respondents amici that handgun bans cannot work. There are simply too many illegal guns already in existence for a ban on legal guns to make a difference. In a word, they claim that, given the urban sea of pre-existing legal guns, criminals can readily find arms regardless. Nonetheless, a legislature might respond, we want to make an effort to try to dry up that urban sea drop by drop, and none of the studies can show that effort is not worthwhile. In a word, the studies to which respondents amici point raise policy-related questions. They succeed in proving that the district's predictive judgments are controversial, but they do not by themselves show that those judgments are incorrect, nor do they demonstrate a consensus, academic or otherwise, supporting that conclusion. Thus, it is not surprising that the district and its amici support the district's handgun restriction with studies of their own. One in particular suggests that, statistically speaking, the district's law has indeed had positive life-saving effects. Others suggest that firearm restrictions, as a general matter, reduce homicides, suicides, and accidents in the home. Still others suggest that the defensive uses of handguns are not as great in number as respondents amici claim. Respondent and his amici reply to these responses, and in doing so, they seek to discredit as methodologically flawed the studies and evidence relied upon by the district. And of course, the district's amici produce counter-rejoinders, referring to articles that defend their studies. The upshot is a set of studies and counter-studies that, at most, could leave a judge uncertain about the proper policy conclusion, but from respondents' perspective, any such uncertainty is not good enough. That is because legislatures, not judges, have primary responsibility for drawing policy conclusions from empirical fact. And given that constitutional allocation of decision-making responsibility, the empirical evidence presented here is sufficient to allow a judge to reach a firm legal conclusion. In particular, this court, in First Amendment cases applying intermediate scrutiny, has said that our sole obligation in reviewing a legislature's predictive judgments is to assure that in formulating its judgments, the legislature has drawn reasonable inferences based on substantial evidence. And judges looking at the evidence before us should agree that the district legislature's predictive judgments satisfy that legal standard. That is to say, the district's judgment, while open to question, is nevertheless supported by substantial evidence. There is no cause here to depart from the standard set forth in Turner, for the district's decision represents the kind of empirically based judgment that legislatures, not courts, are best suited to make. In fact, deference to legislative judgment seems particularly appropriate here, where the judgment has been made by a local legislature, with particular knowledge of local problems and insight into appropriate local solutions. See Los Angeles versus Alameda Books. We must acknowledge that the Los Angeles City Council is in a better position than the judiciary to gather and evaluate data on local problems. And the statement by Representative Good, describing district's law as a decision made on the local level after extensive debate and deliberations. Different localities may seek to solve similar problems in different ways, and a city must be allowed a reasonable opportunity to experiment with solutions to admittedly serious problems. The framers recognized that the most effective democracy occurs at local levels of government, where people with first-hand knowledge of local problems have more ready access to public officials responsible for dealing with them. We owe that democratic process some substantial weight in the constitutional calculus. For these reasons, I conclude that the district statute properly seeks to further the sort of life-preserving and public safety interests that the court has called compelling. I next assess the extent to which the district's law burdens the interests that the Second Amendment seeks to protect. Respondent and his amici, as well as the majority, suggest that those interests include 1. The preservation of a well-regulated militia, 2. Safeguarding the use of firearms for sporting purposes, for example, hunting and marksmanship, and 3. Assuring the use of firearms for self-defense. For argument's sake, I shall consider all 3 of those interests here. The district statute burdens the amendment's first and primary objective hardly at all. As previously noted, there is general agreement among the members of the court that the principal, if not the only, purpose of the Second Amendment is found in the amendment's text, the preservation of a well-regulated militia. What scant court precedent there is on the Second Amendment teaches that the amendment was adopted with obvious purpose to assure the continuation and render possible the effectiveness of militia forces, and must be interpreted and applied with that end in view. Where that end is implicated only minimally, or not at all, there is substantially less reason for constitutional concern. Compare earlier. In the absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches in length at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. To begin with, the present case has nothing to do with actual military service. The question presented presumes that respondent is not affiliated with any state-regulated militia. I am aware of no indication that the district either now or in the recent past has called up its citizenry to serve in a militia, that it has any inkling of doing so any time in the foreseeable future, or that this law must be construed to prevent the use of handguns during legitimate militia activities. Moreover, even if the district were to call up its militia, respondent would not be among the citizens whose service would be requested. The district does not consider him, at 66 years of age, to be a member of its militia. Nonetheless, as some amici claim, the statute might interfere with training in the use of weapons, training useful for military purposes. The 19th century constitutional scholar Thomas Cooley wrote that the Second Amendment protects learning to handle and use arms in a way that makes those who keep them ready for their efficient use during militia service. And former military officers tell us that private ownership of firearms makes for a more effective fighting force because military recruits with previous firearms experience and training are generally better marksmen and accordingly better soldiers. An amicus brief filed by retired Army generals adds that a well regulated militia, whether ad hoc or as part of our organized military, depends on recruits who have familiarity and training with firearms, rifles, pistols, and shotguns. Both briefs point out the importance of handgun training. Handguns are used in military service, and civilians who are familiar with handgun marksmanship and safety are much more likely to be able to safely and accurately fire a rifle or other firearm with minimal training upon entering military service. Regardless, to consider the military training objective a modern counterpart to a similar militia-related colonial objective, and to treat the objective as falling within the amendment's primary purposes makes no difference here. That is because the district's law does not seriously affect military training interests. The law permits residents to engage in activities that will increase their familiarity with firearms. They may register and thus possess in their homes weapons other than handguns, such as rifles and shotguns. See DC Code subsections 7.2502.1, and 7-2502.02a. Only weapons that cannot be registered are sawed-off shotguns, machine guns, short-barreled rifles, and pistols not registered before 1976. And they may operate those weapons within the districts for lawful recreational purposes. Subsection 7.2507.2, and see also subsection 7.2502.01b3. Non-residents participating in any lawful recreational firearm-related activity in the district or on his way to or from such activity in another jurisdiction may carry even weapons not registered in the district. These permissible recreations plainly include actually using and firing the weapons, as evidenced by a specific DC Code provision contemplating the existence of local firing ranges. And while the district law prevents citizens from training with handguns within the district consists of only 61.4 square miles of urban area. The adjacent states do permit the use of handguns for target practice, and those states are only a brief subway ride away. Of course, a subway rider must buy a ticket, and the ride takes time. It also costs money to store a pistol, say at a target range outside the district. But given the costs already associated with gun ownership and firearms training, I cannot say that a subway ticket and a short subway ride and storage costs create more than a minimal burden. For example, see Crawford v. Marion County Election Board acknowledging travel burdens on indigent persons in the context of voting where public transport options were limited. Indeed, respondent and two of his co-plaintiffs below may well use handguns outside the district on a regular basis, as their declarations indicate that they keep such weapons stored there. I conclude that the district's law burdens the Second Amendment's primary objective little or not at all. The majority briefly suggests that the right to keep and bear arms might encompass an interest in hunting, but in enacting the present provisions, the district sought to take nothing away from sportsmen, and any inability of district residents to hunt near where they live has much to do with the jurisdiction's exclusively urban character and little to do with the district's firearm laws. For reasons similar to those I discussed in the preceding subsection, that the district's law does not prohibit possession of rifles or shotguns, and the presence of opportunities for sporting activities in nearby states, I reach a similar conclusion, namely that the district's law burdens any sports-related or hunting-related objectives that the amendment may protect little or not at all. The district's law does prevent a resident from keeping a loaded handgun in his home, and it consequently makes it more difficult for the householder to use the handgun for self-defense in the home against intruders such as burglars. As the Court of Appeals noted, statistics suggest that handguns are the most popular weapon for self-defense, and there are some legitimate reasons why that would be the case. Amici suggest, with some empirical support, that handguns are easier to hold and control, particularly for persons with physical infirmities, easier to carry, easier to maneuver in enclosed spaces, and that a person using one will still have a hand free to dial 911. To that extent, the law burdens to some degree an interest in self-defense that for present purposes I have assumed the amendment seeks to further. In weighing needs and burdens, we must take account of the possibility that there are reasonable but less restrictive alternatives, and there are other potential measures that might similarly promote the same goals while imposing lesser restrictions. C. Nixon. Existence of a clearly superior, less restrictive alternative can be a factor in determining whether a law is constitutionally proportionate. Here I see none. The reason there is no clearly superior, less restrictive alternative to the district's handgun ban is that the ban's very objective is to reduce significantly the number of handguns in the district. Say, for example, by allowing a law enforcement officer immediately to assume that any handgun he sees is an illegal handgun, and there is no plausible way to achieve that objective other than to ban the guns. It does not help respondents' case to describe the district's objective more generally as an effort to diminish the dangers associated with guns. That is because the very attributes that make handguns particularly useful for self-defense also make them particularly dangerous. That they are easy to hold and control means that they are easier for children to use. That they are maneuverable and permit a free hand likely contributes to the fact that they are by far the firearm of choice for crimes such as rape and robbery. That they are small and light makes them easy to steal. This symmetry suggests that any measure less restrictive in respect to the use of handguns for self-defense will, to that same extent, prove less effective in preventing the use of handguns for illicit purposes. If a resident has a handgun in the home that he can use for self-defense, then he has a handgun in the home that he can use to commit suicide or engage in acts of domestic violence. If it is indeed the case, as the district believes, that the number of guns contributes to the number of gun-related crimes, accidents, and deaths, then although there may be less restrictive, less effective substitutes for an outright ban, there is no less restrictive equivalent of an outright ban. Licensing restrictions would not similarly reduce the handgun population, and the district may reasonably fear that even if guns are initially restricted to law-abiding citizens, they might be stolen and thereby placed in the hands of criminals. Permitting certain types of handguns, but not others, would affect the commercial market of handguns, but not their availability. And requiring safety devices such as trigger locks or imposing safe storage requirements would interfere with any self-defense interest while simultaneously leaving operable weapons in the hands of owners or others capable of acquiring the weapon and disabling the safety device, who might use them for domestic violence or other crimes. The absence of equally effective alternatives to a complete prohibition finds support in the empirical fact that other states and urban centers prohibit particular types of weapons. Chicago has a law very similar to the district's, and many of its suburbs also ban handgun possession under most circumstances. And San Francisco in 2005 enacted by popular referendum a ban on most handgun possession by city residents. It has been precluded from enforcing that prohibition, however, by state court decisions deeming it preempted by state law. Indeed, the fact that as many as 41 states may preempt local gun regulation suggests that the absence of more regulation like the districts may perhaps have more to do with state law than with a lack of locally perceived need for them. In addition, at least 6 states and Puerto Rico impose general bans on certain types of weapons, in particular assault weapons or semi-automatic weapons. And at least 14 municipalities do the same. These bans, too, suggest that there may be no substitute to an outright prohibition in cases where a governmental body has deemed a particular type of weapon especially dangerous. The upshot is that the district's objectives are compelling. Its predictive judgments as to its law's tendency to achieve those objectives are adequately supported. The law does impose a burden upon any self-defense interest that the amendment seeks to secure, and there is no clear, less restrictive alternative. I turn now to the final portion of the permissible regulation question. Does the district's law disproportionately burden amendment-protected interests? Several considerations taken together convince me that it does not. First, the district law is tailored to the life-threatening problems it attempts to address. The law concerns one class of weapons, handguns, leaving residents free to possess shotguns and rifles along with ammunition. The area that falls within its scope is totally urban. That urban area suffers from a serious handgun fatality problem. The district's law directly aims at that compelling problem, and there is no less restrictive way to achieve the problem-related benefits that it seeks. The second, the self-defense interest in maintaining loaded handguns in the home to shoot intruders is not the primary interest, but at most a subsidiary interest that the Second Amendment seeks to serve. The Second Amendment's language, while speaking of a militia, says nothing of self-defense. As Justice Stevens points out, the Second Amendment's drafting history shows that the language reflects the framers' primary, if not exclusive, objective. And the majority itself says that the threat that the new federal government would destroy the citizens' militia by taking away their arms was the reason that right was codified in a written constitution. The way in which the amendment's operative clause seeks to promote that interest by protecting a right to keep and bear arms may in fact help further an interest in self-defense, but a factual connection falls far short of a primary objective. The amendment itself tells us that militia preservation was first and foremost in the framers' minds. C. Miller, with obvious purpose to assure the continuation and render possible the effectiveness of militia forces, the declaration and guarantee of the Second Amendment were made, and the amendment must be interpreted with and applied with that end in view. Further, any self-defense interest at the time of the framing could not have focused exclusively upon urban crime-related dangers. 200 years ago, most Americans, many living on the frontier, would likely have thought of self-defense primarily in terms of outbreaks of fighting with Indian tribes, rebellions such as Shays' Rebellion, marauders, and crime-related dangers to travelers on the roads, on footpaths, or along waterways. Insofar as the framers focused at all on the tiny fraction of the population living in large cities, they would have been aware that these city dwellers were subject to firearm restrictions that their rural counterparts were not. They were unlikely then to have thought of a right to keep loaded handguns in homes to confront intruders in urban settings as central, and the subsequent development of modern urban police departments by diminishing the need to keep loaded guns nearby in case of intruders would have moved any such right even further away from the heart of the amendment's more basic protective ends. Nor for that matter am I aware of any evidence that handguns in particular were central to the framers' conception of the Second Amendment. The lists of militia-related weapons in the late 18th century state statutes appear primarily to refer to other sorts of weapons, muskets in particular. Respondent points out in his brief that the federal government and two states at the time of the founding had enacted statutes that listed handguns as acceptable militia weapons, but these statutes apparently found them acceptable only for certain special militiamen, generally certain soldiers on horseback, while requiring muskets or rifles for the general infantry. Third, irrespective of what the framers could have thought, we know what they did think. Samuel Adams, who lived in Boston, advocated a constitutional amendment that would have precluded the Constitution from ever being construed to prevent the people of the United States, who are peaceable citizens, from keeping their own arms. Samuel Adams doubtless knew that the Massachusetts Constitution contained somewhat similar protection, and he doubtless knew that Massachusetts law prohibited Bostonians from keeping loaded guns in the house. So how could Samuel Adams have advocated such protection unless he thought that the protection was consistent with local regulation that seriously impeded urban residents from using their arms against intruders? It seems unlikely that he meant to deprive the federal government of power to enact Boston-type weapons regulation that he knew Boston had, and as far as we know, he would have thought constitutional under the Massachusetts Constitution. Indeed, since the District of Columbia, the subject of the seat of government clause, was the only urban area under direct federal control, it seems unlikely that the framers thought about urban gun control at all. For example, see Palmore v. United States. Congress can legislate for the district in a manner with respect to subjects that would exceed its powers, or at least would be very unusual in the context of national legislation enacted under other powers delegated to it. Of course, the district's law and the colonial Boston law are not identical, but the Boston law disabled an even wider class of weapons, indeed all firearms, and its existence showed at the least that local legislatures could impose, as here, serious restrictions on the right to use firearms. Moreover, as I have said, Boston's law, though highly analogous to the district's, was not the only colonial law that could have impeded a homeowner's ability to shoot a burglar. Pennsylvania's and New York's laws could well have had a similar effect. and the Massachusetts and Pennsylvania laws were not only thought consistent with an unwritten common law gun possession right, but also consistent with written state constitutional provisions providing protections similar to those provided by the federal Second Amendment. I cannot agree that with the majority that these laws are largely uninformative because the penalty for violating them was civil rather than criminal. The court has long recognized that the exercise of a constitutional right can be burdened by penalties far short of jail time. See also Forsyth County v. Nationalist Movement. A tax based on the content of speech does not become more constitutional because it is a small tax. Regardless, why would the majority require a precise colonial regulatory analog in order to save a modern gun regulation from constitutional challenge? After all, insofar as we look to history to discover how we can constitutionally regulate a right to self-defense, we must look not to what 18th century legislatures actually did enact, but to what they would have, but to what they would have thought they could enact. There are innumerable policy-related reasons why a legislature might not act on a particular matter, despite having the power to do so. This court has frequently cautioned that it is, at best, treacherous to find in constitutional silence alone the adoption of a controlling rule of law. See United States v. Wells. It is similarly treacherous to reason from the fact that colonial legislatures did not enact certain kinds of legislation to a conclusion that a modern legislature cannot do so. The question should not be whether a modern restriction on a right to self-defense duplicates a past one, but whether that restriction, when compared with restrictions originally thought possible, enjoys a similarly strong justification. At a minimum, that similarly strong justification is what the district's modern law, compared with Boston's colonial law, reveals. Fourth, a contrary view, as embodied in today's decision, will have unfortunate consequences. The decision will encourage legal challenges to gun regulation throughout the nation. Because it says little about the standards used to evaluate regulatory decisions, it will leave the nation without clear standards for resolving those challenges. In litigation over the course of many years, or the mere specter of such litigation, threatens to leave cities without effective protection against gun violence and accidents during that time. As important, the majority's decision threatens severely to limit the ability of more knowledgeable, democratically elected officials to deal with gun-related problems. The majority says that it leaves the district a variety of tools for combating such problems. It fails to list even one seemingly adequate replacement for the law it strikes down. I can understand how reasonable individuals can disagree about the merits of strict gun control as a crime control measure, even in a totally urbanized area, but I cannot understand how one can take from the elected branches of government the right to decide whether to insist upon a handgun-free urban populace in a city now facing a serious crime problem and which, in the future, could well face environmental or other emergencies that threaten the breakdown of law and order. The majority derides my approach as judge empowering. I take this criticism seriously, but I do not think it is accurate. As I have previously explained, that this is an approach that the court has taken in other areas of constitutional law. Application of such an approach, of course, requires judgment, but the very nature of the approach, requiring careful identification of the relevant interests and evaluating the law's effect upon them, limits the judge's choices, and the methods necessary transparency lays bare the judge's reasoning for all to see and to criticize. The majority's methodology is, in my view, substantially less transparent than mine. At a minimum, I find it difficult to understand the reasoning that seems to underlie certain conclusions that it reaches. The majority spends the first 54 pages of its opinion attempting to rebut Justice Stevens' evidence that the amendment was enacted with a purely militia-related purpose. In the majority's view, the amendment also protects an interest in armed personal self-defense, at least to some degree. But the majority does not tell us precisely what that interest is. Putting all of the Second Amendment's textual elements together, the majority says, we find they guarantee the individual right to possess and carry weapons in case of confrontation. Then 3 pages later, it says that we do not read the Second Amendment to permit citizens to carry arms for any sort of confrontation. Yet with one critical exception, it does not explain which confrontations count. It simply leaves that question unanswered. The majority does, however, point to one type of confrontation that counts, for it describes the amendment as elevating above all other interests the right of law-abiding responsible citizens to use arms in defense of hearth and home. What is its basis for finding that to be the core of the Second Amendment right? The only historical sources identified by the majority that even appear to touch upon that specific matter consist of an 1866 newspaper editorial discussing the Freedmen's Bureau Act, two quotations from the 1866 Act's legislative history, and a 1980 state court opinion saying that in colonial times the same were used to defend the home as to maintain the militia. How can citations such as these support the far-reaching proposition that the Second Amendment's primary concern is not its stated concern about the militia, but rather a right to keep loaded weapons at one's bedside to shoot intruders? Nor is it at all clear to me how the majority decides which loaded arms a homeowner may keep. The majority says that the amendment protects those weapons typically possessed by law-abiding citizens for lawful purposes. This definition conveniently excludes machine guns but permits handguns, which the majority describes as the most popular weapon chosen by Americans for self-defense in the home. But what sense does this approach make? According to the majority's reasoning, if Congress and the states lift restrictions on the possession and use of machine guns, and people buy machine guns to protect their homes, the court will have to reverse course and find that the Second Amendment does, in fact, protect the individual self-defense related right to possess a machine gun. On the majority's reasoning, if tomorrow someone invents a particularly useful, highly dangerous self-defense weapon, Congress and the states had better ban it immediately, for once it becomes popular, Congress will no longer possess the constitutional authority to do so. In essence, the majority determines what regulations are permissible by looking to see what existing regulations permit. There is no basis for believing that the framers intended such circular reasoning. I am similarly puzzled by the majority's list in Part 3 of its opinion of provisions that, in its view, would survive Second Amendment scrutiny. These consist of 1. Prohibitions on carrying concealed weapons, 2. Prohibitions on the possession of firearms by felons, 3. Prohibitions on the possession of firearms by the mentally ill, 4. Laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, and 5. Government conditions and qualifications attached to the commercial sale of arms. Why these? Is it that similar restrictions existed in the late 18th century? The majority fails to cite any colonial analogs. And even were it possible to find analogous colonial laws in respect to all these restrictions, why should these colonial laws count, while the Boston loaded gun restriction, along with the other laws I have identified, apparently does not count? At the same time, the majority ignores a more important question. Given the purpose for which the framers enacted the Second Amendment, how should it be applied to modern-day circumstances that they could not have anticipated? Assume, for argument's sake, that the framers did intend the amendment to offer a degree of self-defense protection. Does that mean the framers also intended to guarantee a right to possess a loaded gun near swimming pools, parks, and playgrounds? That they would not have cared about the children who might pick up a loaded gun on their parents' bedside table? That they, who certainly showed concern for the risk of fire, would have lacked concern for the risk of accidental deaths or suicides that readily accessible loaded handguns in urban areas might bring? Unless we believe that they intended future generations to ignore such matters, answering questions such as the questions in this case requires judgment. Judicial judgment exercised within the framework for constitutional analysis that guides that judgment and which makes its exercise transparent. One cannot answer those questions by combining inconclusive historical research with judicial ipse dixit. The argument about method, however, is by far the less important argument surrounding today's decision. Far more important are the unfortunate consequences that today's decision is likely to spawn. Not least of these, as I have said, is the fact that the decision threatens to throw into doubt the constitutionality of gun laws throughout the United States. I can find no sound legal basis for launching the courts on so formidable and potentially dangerous a mission. In my view, there simply is no untouchable constitutional right guaranteed by the Second Amendment to keep loaded handguns in the house in crime-ridden urban areas. For these reasons, I conclude that the district's measure is a proportionate, not a disproportionate, response to the compelling concerns that led the district to adopt it. And for these reasons, as well as the independently sufficient reasons set forth by Justice Stevens, I would find the district's measure consistent with the Second Amendment's demands. With respect, I dissent. Well, that was a nice read. And as always, if there's any case you'd like me to read, just drop in the comments and I'm happy to take a look. Thank you.